Honorable Justices. My name is Shah, first initial N, and I am here with my co-counsel, Rana, first initial M, representing the appellant, Her Majesty the Queen, in the case at bar. I will be addressing the final two submissions. First, the respondent's Section 9 charter rights to be free from arbitrary detention were not violated. And second, the evidence should be admissible under Section 24(2), as excluding the evidence can lead to broader societal and judicial implications. To begin, the appellant submits that the respondent's Section 9 charter rights were not violated, as he was not arbitrarily detained since the detention was based on reasonable grounds, and the subjective belief of detention factors into the analysis of whether or not a detention occurred per grant. The legal principles involved in the consideration of whether a detention occurred include how the conduct of the police might have reasonably been perceived by the accused, especially given that one of the investigations they were pursuing concerned activities and/or individuals potentially in the backyard, the nature and duration of the police interaction with the accused and his friends, including how the police addressed the accused, and the young age, visible minority status, and slight physical stature of the accused. The law as currently formulated and as applied by the trial judge suggests that a person is not detained because he is asked preliminary general questions by the police. The trial judge correctly applies these principles at paragraphs 85 and 89, where he concluded that there was no detention until there was a focused investigation on the accused when he was asked about the bag. At that moment, he was detained. A physical detention did not occur until the accused fled the scene immediately after, actions which created reasonable grounds for detention. With regard to psychological detention, the objective test established in Grant asks the court to determine if a reasonable person in the respondent's circumstances would conclude that they were not free to go and had to comply with police direction. We submit that the respondent's subjective belief that he was not detained and was free to leave is a strong indication that he did not feel psychologically detained. Based on the conclusion that the respondent was only detained when Constable O'Toole asked him what was in his bag, the respondent's detention is lawful. Constable O'Toole had reasonable grounds to suspect that the respondent was armed given his blading, and that reasonable suspicion justifies an investigative detention as established in Mann. The case of Mackenzie outlines the reasonable suspicion standard where, quote, in assessing whether a case for reasonable suspicion has been made out, the analysis of objective reasonableness should be conducted through the lens of a reasonable person standing in the shoes of the police officer, close quote. This test takes into account officer training and experience, and based on their training and experience, the respondent's movements in the situation in question had simultaneously aroused the suspicion of two police officers. As stated by the Court of Appeal, police officers are trained to recognize blading, which describes a body movement whereby a person attempts to position himself so that an officer cannot see an object sitting on the person's hip. Police are also trained to associate this stance with the possession of a firearm, so when the officers noticed the respondent blading, they were justifiably concerned. So to restate your question, you are asking if it would matter to my analysis if there was no fence defining the property line when the officers began interacting with the occupants of the backyard, correct? This leads to the question of whether the lawfulness of the respondent's detention changes if the police officers were to be found trespassing, which may be the case if there was no fence defining the property line. However, we submit that the lawfulness would not change. For starters, the determination of detention has no connection to the status of police officers being on the property, given that, as we've established, a reasonable person in the respondent's position would not have considered themselves detained until Constable O'Toole asked about the contents of the respondent's bag. The purpose of Section 9 is to protect individuals from unlawful state intrusion upon the liberty of the individual. However, there was no intrusion upon the respondent's liberty until Constable O'Toole asked Mr. Lee what was in his bag. Even if the officers were considered to be trespassing, it would have no impact on the fact of the respondent's liberty. His liberty was only limited after the constable had reasonable grounds to suspect that the respondent was armed, and at that point, as stated earlier, the lawful detention took place. Due to the fact that the police did not enter the property with the intention of detaining anyone, the eventual detention cannot be considered arbitrary or unlawful. In conclusion, the respondent's Section 9 charter rights were not violated. Section 24(2) of the Charter dictates that where evidence is obtained in a manner that infringed or denied an accused's charter rights and/or freedoms, the evidence shall be excluded if it is established that having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. As presented in our first two submissions, the evidence was not obtained in an unlawful manner, as neither the respondent's Section 8 nor Section 9 rights were violated. Therefore, the evidence should not be excluded. The test to determine whether evidence should be excluded pursuant to Section 24(2) of the Charter is outlined in Grant. The Grant test requires that the court assess and balance the effect of admitting the evidence on society's confidence in the justice system, having regard to 1. The seriousness of the Charter infringing state conduct, 2. The impact of the breach on the Charter-protected interest of the accused, and 3. Society's interest in adjudication of the case on its merits. Each of these three prongs of the test is viewed in a long-term, forward-looking, and societal perspective. To address the first prong, even if a charter violation occurred, it is not particularly serious, as any potential breach was technical, inadvertent, and made in good faith. Following this logic, the impact of the breach is not serious, as, if we accept the lower court's finding that he was only psychologically detained for mere seconds, which was based on the reasonable presumption that he was in possession of a weapon, then the breach of his rights, if found to be in fact a breach, was not serious. Additionally, the respondent acknowledges that the evidence seized is reliable and integral to the Crown's case, and so the evidence is essential to society's interest in the adjudication of the case on its merits. As a result, when accounting for all three aspects of the Grant test, it can be concluded that the evidence should not be excluded under Section 24(2). In addition, it is necessary to protect the public from the scourge of drugs and gun violence, especially on Vanali Walk and surrounding areas which have a reputation for this type of illicit and dangerous activity. As a result, if the court finds that the respondent's rights were limited, said limitation is justifiable pursuant to Section 1, given that it is demonstrably justified in a free and democratic society. In other words, limiting an individual's charter rights must be reasonable insofar as it seeks to address an issue of pressing or substantial concern, and we submit that drug crimes and gun violence are a substantial concern. Finally, the approach the respondent proposes can have potentially broad implications. It would open the floodgates for future claimants bringing forth Section 8 and/or 9 charter challenges, which would need to be settled in court trials. It would also redefine the focus of Section 8 from protecting personal privacy to assessing the legality of all police actions. Additionally, the respondent's factual guilt was never an issue, so if this appeal is allowed and becomes the new precedent, this decision will expand the scope of Section 8 in a manner that unnecessarily limits police powers and hinders their ability to ensure public safety. Thus, it will enable future accused persons to claim charter protection wherein they can get off on a technicality. Barring any further questions, this concludes the appellant's submissions.